Welcome, everyone, to this week's session of Law as Science. I am Marilyn Haj, SJD candidate at UVA School of Law. I will serve as your moderator for this session. Before turning to today's esteemed speaker, Cynthia Nicoletti, let me briefly introduce the Law as Science project. Law as Science is an academic initiative coordinated by a group of JSD candidates from across the United States who share the same belief in legal methodologies. Legal methodologies are often understood as a discipline distinct from sciences, traditionally consisting of doctrinal analysis and normative questions. Through this series of interdisciplinary talks, we aim to show that legal research can be improved and benefit from scientific methodologies that provide systemic ways to approach questions. If you want to learn more about the Law as Science project, please visit our website and join our email list. One of our awesome coordinators will drop the links in the chat. Speaking of coordinators, I would like to take a moment to introduce our team. We have Simon Sun joining us from Taiwan, who is the co-founder of this initiative and assistant professor at National Yangming Chiao Tong University School of Law. We've got Studi Shah, who's a JSG candidate at Columbia Law. We've got Sung Chun Chen, JSG candidate at University of Illinois Urbana-Champaign School of Law. And we've got Vanessa Villanueva, who is the senior fellow here at Law as Science and the chief editor of our blog, The Legal Method Lab. We also have representatives for numerous law schools across the United States, such as UC Berkeley, UPenn, University of Illinois, University of Washington, Columbia, and Fordham. If you are interested in getting involved, we are always looking for new law as science representatives. We also host a blog on legal methodology, The Legal Method Lab, and we're always on the lookout for new editors. So if you are interested in becoming either a representative or an editor, please reach out to us. But enough with the shameless marketing. Let's turn to today's speaker. Cynthia Nicoletti is a legal historian and is the Paul G. Mahoney Research Professor of Law and Professor of History at UVA School of Law. She has received numerous awards and fellowships, including the William Nensel Cromwell Prize for the Best Dissertation in Legal History, awarded by the American Society for Legal History in 2011. Her book, Secession on Trial, The Treason Prosecution of Jefferson Davis, won the 2018 Cromwell Book Prize, given by the William Nensel Cromwell Foundation each year for excellence in scholarship to an early career scholar working in the field of American legal history. Professor Nicoletti holds many degrees, including a JD from Harvard Law and a PhD from UVA. Her work embodies exactly law as science interdisciplinary spirit. It combines deep historical insight with rigorous legal analysis to shed new light on complex issues of American legal development. By investigating how historical contexts shape legal outcomes and doctrines, Professor Nicoletti not only enriches our understanding of the law's past, but also sharpens our critical analysis of its role in contemporary society. Today, she will be discussing the legal history of the American Civil War, a subject perfectly positioned at the intersection of historical inquiry and legal theory. Her approach highlights the importance of interdisciplinary scholarship, something we deeply value here at Law as Science. On a very final note, we will have a Q&A segment at the end of the session, so please stay tuned till the end, prepare some questions. We look forward to a tantalizing conversation with you. But now, without further ado, Professor Nicoletti, the floor is yours.
Great. Thank you. And thank you, Marilyn, for that lovely introduction. And thank you to all of you for all the coordinating. Sounds like there's been a lot of that with all the things you have going on. And thank you for coming. So I'm going to have sort of three topics I'm going to talk about today. So I plan first to talk just a little bit about legal history and how I think about legal history at the beginning. I'm thinking that might be a space where you guys want to ask me more questions at the end. So first I'm going to talk about sort of legal history in general. And then I'm going to talk a little bit about my work. So I'm going to talk, Marilyn talked about my first book, which is finished. Thank God. And so I'm going to talk a little bit about my first project and what that looked like. And then I'm going to talk thirdly about the book that I'm working on right now. So to give you just a glimpse into what I'm doing. So that's the plan, to talk more broadly and then more narrowly. Okay, so first, I guess I want to talk about what I'm interested in as a legal historian. What you said at the beginning about various methods of inquiry, Marilyn, is really interesting to me. I feel like when I say that I'm a legal historian, most law students think that I'm an originalist, and I'm not. So I guess I wanted to talk just a little bit about that. And I have to say, I'm quite glad that, the importance of originalism today, I think, makes legal historians look more interesting to lawyers in general. But I do want to clarify that that's really not my approach and it's not what I do. So I think originalists are interested in, looking to history to get answers for modern questions. And I would say that I am less interested in modern questions. I mean, I'm not, you know, I don't, I don't just repel modern questions, but it's not the central aspect of my work by any means. Now, I mean, I'm sure that, at some point there were some modern questions that got me interested in history in the first place, but I don't really, I really write in the past. And so my scholarship is located in the past. And I am interested really in how people in the past were thinking about legal questions. So, I'm really interested in sort of denaturalizing how things happened. I feel like when we sort of tell the legal history of any period, it tends to look pretty natural to us, right? So today, right, looking back, well, of course that thing happened, right? And I'm really interested in trying to figure out why things happened and really sort of taking seriously the idea that this is not a natural occurrence, right? History was not just designed to unspool this way. And I'm interested in thinking about how events in the past, right, that we take for granted today, and we sort of build into our narrative of, what it means to be an American, or, what it means to understand American history, how to think about those things as the product of contingency. And I think really importantly for me, human striving. Right. So it's historical events. And I think, as a legal historian, I'm really interested in sort of exploring, like, okay, so here are some big structural things that are happening, like war. I mean, I'm interested in the Civil War, so I am interested in war. But I'm interested in sort of big structures and how those interact with individual decision making by flawed human beings. And sort of the intersection of those two things. So I'm interested in sort of denaturalizing my own understanding and hopefully my audience's understanding of why things happened. And I guess I would also say, as a historian, this is my approach, but it is probably, I don't know, it's not unique to me, but I don't know that every historian would say the same thing. I am very interested in people. So I have a lot of lawyers in my stories, in the histories that I tell. And it's not to say that I think that, lawyers are the only important people in telling legal history, but I do really I do really think that the actions of lawyers and how they think about sort of larger social problems, and the way in which law constrains what their activity is going to be. Do they think about law as something that they can stretch? Or do they think about law as a constraint on their actions? How are they thinking about law? How does it sort of condition what they're doing? And I guess I would say that I do think that there are a lot of really important things that we sort of understanding about our own legal history that were not just things that happened. I think that there are probably lawyers at the center of lots of things in our legal history that we just really don't know the story. And I'm interested in sort of exploring stories about how these things happened. So I would say that um, my job is really fun. I mean, it's important and awesome, but it's also really fun because there are a lot of puzzles in what I do, and I feel like a detective quite often. So I do a lot of archival work in my research. So I told you I'm interested in people. So I look for people's papers, and I'm looking to sort of figure out how different people are interacting and this is where the detective work comes in. So I feel like that was pretty oblique. So I thought I might give you an example from something I did recently. So we had spring break a couple of weeks ago. And I went to Indiana to do, very exciting, to do some research in the archives at Indiana University. So at the center of my story, I've got this lawyer, and he makes all kinds of arguments about various statutes during Reconstruction and how they should be construed. And I know that his ideas, he's a private lawyer, and so I know that his ideas eventually get adopted. And so this question in my head was, okay, well, how are his ideas received? He is certainly making arguments to people in the executive branch, and certainly the executive branch starts acting in accordance with what he's saying, right? So I'm thinking, okay, I really want to be able to figure out how do these ideas sort of get into the heads of people in the executive branch. And so I went to Indiana because this is where the papers of the Secretary of the Treasury under President Johnson, Andrew Johnson, his papers are there. And so I went through his papers for the week. And indeed, I found a bunch of letters, right, where he has correspondence from my main lawyer, who's this guy, William Henry Trescott. And he says, oh, Trescott came to visit me. I see Trescott's letters. And then there's a letter I found where he writes to the president, to Andrew Johnson, by the way, Trescott's right about this. This is a big problem. We have to figure out how to fix it, something like that. And I almost did a Yelp in the archives. That was like a great moment where I'm thinking like, okay, I have parts of this story, right, about here's this thing that comes about. I'm being a little oblique. I will get into some of the details later, right? But I have this story and here's how it turns out. I want to put the pieces together to figure out, okay, so how does this actually happen? How do these ideas get into people's heads, right? Why are they convincing, that type of thing? Yeah, so I would say I'm pretty human oriented in the way that I'm looking to tell my stories. I guess I want to back up a little and just talk about Civil War history more generally, and legal history and how that figures in. So I've always been interested, as far back as I can remember as a kid. I've been interested in Civil War history for a long time. I would say that there are a lot of big questions involved in the American Civil War that I'm interested in. So the question of nationhood, right? So we have this big question of the integrity of the United States as a nation, right? So the Civil War, is a secession movement, starts as a secession movement by the Southern states. And there's this question of state sovereignty versus nationhood. Are we going to continue as a nation? What are the relative powers of the states and the national government? That's a big question. We also have huge questions about race and slavery in America, right? So this is the time that that slavery ends in the United States. We have big questions about civil liberties, right? There are lots of free speech questions and arbitrary arrests in the middle of the Civil War. And I think fundamentally for me, one of the big questions is about war and the rule of law and how the rule of law operates, how we think about law in the midst of a crisis, right? So I have always thought um, it's surprising to me that everyone who is a legal historian is not a legal historian of the Civil War. I know that's self-serving, but my thought there has always been, well, I'm really interested in how Americans think about law and how it sort of structures our society, and how central do we think that that is to the American project, which I think is always true if you're an American legal historian, but the Civil War puts those ideas under stress, and we see sort of events happen sort of at a dizzying pace, right? History moves at a dizzying pace during the war. They're constantly under stress. And so some of these ideas about how important law is in American life and to American government, you see people they float to the surface more. You see people talking about them more directly because they're really confronted by, sort of a dizzying pace of events. And so all of those questions are involved in the legal history of the American Civil War. Yeah, so these are so these are sort of the big questions I'm interested in. I guess I would also say that this is a field that I think maybe surprisingly, there is a ton of work to be done in, right? So my encouragement to everyone on this Zoom, but just in general, there's lots of work, really good work that legal historians can do. So there's a lot of, work in the legal history of the Civil War, but it tends to be, for the most part, quite old, right? So the first sort of professional histories of the Civil War were legal history and military history, but they were written, I would say, in the late 19th century, beginning then, and they were very sort of great man history, and the action was just they read statutes and they read cases, and that was pretty much it. And so we have a lot more tools at our disposal now as historians, and has the field of history really has gotten to social history and telling histories from below. And so if you sort of take our new tool set, right, there are so many questions to be explored, lots of work to be done. Okay, so that was sort of my thoughts about the Civil War in general. So I'll talk a little bit and hope to leave lots of time for questions about both of the projects that I've worked on. So both of the projects that I've worked on for me have been about sort of big questions about the legal history of the Civil War that I feel like we just didn't know that much about. And I feel like maybe surprisingly so. So the first project I worked on, my first book, is called Secession on Trial, the Treason Prosecution of Jefferson Davis. And it's about this question of how is it that the Civil War settles this question that the Union is permanent and that states cannot secede at will from the Union, right? Now, maybe that seems pretty basic today, but that is a question that we've always known that the Civil War settles that legal question. And I guess the sort of traditional answer has been to that question, well, Southern states seceded from the Union, and the Union said you can't secede. And then we won the war, right? The Union won the war. The end. That's sort of the story that gets told. And I thought, yeah, I think it's a little more complicated than that. And I think I think it's a little more complicated than that because we are a society, right, that has tended to prize the rule of law, right? So isn't it a problem in a society like that to just say, okay, well, might makes right, Union victory on the battlefield, that's the end of the question. And so what I did in the book is I looked at a test case that was supposed to be a case after the war, looking at that really raised this question about the legitimacy of secession. It was a high profile case, and it was Jefferson Davis's treason trial. So Jefferson Davis was the president of the Confederacy, or should I say, the president of the so-called purported Confederacy. And after the war, the government thinks very seriously about trying him for treason against the United States. And treason under the United States Constitution, it's quite easy to prove that Davis committed treason. So the Constitution says that treason consists in levying war against the United States. I mean, there are other definitions too. You can also give aid to the enemies of the United States. But if we take this definition that treason consists in levying war against the United States, it's very clear that the president of the Confederacy levied war against the United States. Indeed, that is his whole job, right? It's like get up in the morning, levy war against the United States. And so the question really comes, the question is whether or not he is a United States citizen, right? So treason is a crime of loyalty. Traditionally, you have to be a citizen, right, in order to commit treason against the United States. And it's anticipated that his defense is going to be, well, my state seceded from the Union, I'm no longer an American, right? I don't owe any loyalty, right? I mean, someone who is a foreign national could commit any kinds of crimes, in the United States, but treason, right, is a crime of loyalty. And so it's anticipated that his defense is going to turn on the legitimacy of secession. And after the war, there's this great big rush to put Davis on trial for treason, really to sort of cement the judgment of the battlefield, right, and have it declared in a court of law and not just on the battlefield that secession is illegal. Now, as it turns out, I have a whole book on a trial that never happened. So Davis does not ultimately get tried for treason against the United States. And in large part, that's because he has a very good lawyer. So here's where his lawyer, and where this idea of lawyers really is central to the project. So his lawyer raises with the Johnson administration the prospect that potentially Davis could be acquitted, right? So he has to be tried in accordance with the Constitution in the place where he committed his crime, which is in Richmond, Virginia, which was the capital of the Confederacy. And where the jury pool, well, it might be said, might have some Confederate sympathizers on the jury. There are also some reasons that secession might be useful to the judges in surprising ways. I could talk more about that in the Q&A, but his lawyer really raises the prospect that his client could be acquitted. And largely, his lawyer is trying to ensure that Davis doesn't get tried for treason because he's worried that if Davis gets convicted, he'll be killed, right? So the crime of treason, right, carried the punishment of death. And so what his lawyer does is he sort of strategically raises the prospect that secession could be, vindicated in a court of law, right, in order to ensure that Davis doesn't actually get tried for the crime of treason. And the Supreme Court does eventually, the Supreme Court of the United States does eventually declare secession to be illegal. But it does so in a case that it's really surprising, right? That the court sort of reaches for the question in a case that is far less volatile than Davis's case is, right? There really isn't a prospect where secession, could have this surprising vindication. And so, and I should say that it's the same judge, right? So it's the Chief Justice of the United States, Salmon Chase, who is supposed to preside over Davis's trial, and also is the person who, in this case of Texas versus White, that the Supreme Court hears in 1869, declares secession to be unconstitutional. So the book really sort of complicates, the point of the book really is to complicate the idea that secession is declared unconstitutional after the Civil War, right? And to talk about how actually that's quite a complicated process, right? And it takes a good deal of engineering on the part of lawyers and judges, right, to ensure that, it's not just a battlefield outcome, right, where secession is declared unconstitutional. So the decision of the courts does actually end up, coinciding with the decision of the battlefield. So that's my first project. Happy to talk more about that. But I thought I would talk a little bit about what I'm currently working on. And so what I'm currently working on is a project on the prospect of land redistribution after the Civil War. So here I'm talking about this idea that is sort of floating at the end of the Civil War to take land from former Confederates, people who committed treason, and to redistribute that to formerly enslaved people at the end of the Civil War, right? So there's this idea that I mean, is sort of in American discourse today about the idea that we could have really had a much more meaningful idea of American freedom, right, for Black Americans at the end of the Civil War if there had been property grants, right, that accompanied the Declaration of Emancipation at the end of the Civil War. And so I guess like sort of the common parlance for this in American life is probably this idea of 40 acres and a mule. Maybe you've heard of this, right? And the idea is that that freed people would be granted 40 acres of land. I mean, we're in the 19th century, so land is wealth in the 19th century. And so that there would have been this idea of property grants to Black people at the end of the war. So this did not happen. And the traditional story that we've told is, well, the Republican Congress at the end of the Civil War is quite racist, right? And is not interested in making property grants to Black people at the end of the war. This is sort of a pipe dream, never going to happen. And so it's an idea that really never gets off the ground. That's sort of the story that we tell ourselves. And I was interested in, okay, so I should also say I am a property professor. So I should also say that in the back of my mind was, well, how did this actually work? Was there a plan? How were property grants going to actually work? And this idea of land redistribution, well, was it just an idea? What did it look like? I want to know what the grant looks like. I'm a property professor. So this is sort of the idea that I started with. And as it turns out, this is really quite a complicated story. And the story that we tell ourselves, which is that it was never going to happen, is false. So the book as I'm writing it right now sort of comes in two parts, which is wartime and then post-war. And it turns out that actually during the war, there is a plan in place to grant land to Black people. So there is a plan, and I should say that this plan consists of two parts, right? One is land seizure, right? How is it that the government is actually going to seize land, right, from former Confederates? Where's the land going to come from? And so they are thinking about land seizure. So they're thinking about land grants in the American South, right? And so they're thinking about, okay, so how do we seize land, right, legally, right, from former Confederates? And then how are we going to grant it? And as I figured out that actually the problem is not so much with the grant, because most people who, I would say even racists, right? People who believe in emancipation do believe that freedom in the 19th century really has to be meaningful, has to be accompanied by a land grant, a property grant, which was surprising to me that they believe that those things were so closely linked, but I think they do. So they do think that land grants are a component of freedom. The problem is with the land seizure, right? And so they have sort of a hodgepodge of various programs by which they're going to seize land from white people, right, from like former Confederates. And I should say some of it is, Marilyn, you might be a tax person. Part of it is a tax plan. That's actually the only part that works. So there's a tax plan, and there are military seizures. There are some seizures by the Treasury Department, and then there's this idea of also treason convictions, right, which are supposed to come with stripping of property rights. And so I should say none of those are really, nobody sits down and figures out, well, how are we going to put all of this together, right, to actually make the land seizure work? That's part of it, that they don't do enough planning. But the plan is sort of in place, and they have like a hodgepodge of measures, right, to make land redistribution actually work by war's end. And then the idea is that it would continue in the post-war period. Okay, so that's sort of the first part of the project. And then the second part is, okay, so we have land redistribution at least tentatively in place by the end of the war, but then we get a bunch of lawyers. And particularly, I will say, very active lawyers, activist lawyers on the part of the Southern planter class, who for the next 30 years, it takes them 30 years to actually unravel, right, what's already in place with land redistribution. And they do it, right, by challenging I would say quite informally, not just in the courts, right? Like a lot of this is done through informal lobbying with the president and with the executive branch and also lobbying Congress in terms of, and they get like statutes actually changed to not really mess with the idea of granting land to Black people. What they do is they try to shrink the supply of land to nothing. And they're really quite effective at doing that. And I would also say quite effective at covering their tracks, right? So there's some litigation, but there's not much. And a lot of it is done quite informally, right? So you have to sort of follow the private papers of these lawyers, right? And I figured out, like who's in the network of lawyers who's really doing this lobbying. And so what they do is, I would say a stealth campaign, and they're actually quite explicit about, we want this to be stealthy, right? We don't want it to be announced to the world, right? That what we're doing is we're trying to kill this program. And so they do it sort of piece of land by piece of land. And there's some point when my main lawyer, who is this South Carolinian named William Henry Trescott, who's sort of one of the ringleaders of the lawyers, he says, our plan is going to be less successful, right, if we sort of broadcast this as we have a plan and a strategy. And so they do it quite stealthily. And I will say they're successful, right? And part of the success is actually sort of covering over, the historical, what would I say, trail, right, about this story, right? So the story we tell ourselves, I think, is largely untrue, but they try to construct, I think, that story, right, by, conducting this sort of stealth campaign, and which is one thing that makes it fun as a legal historian to go back and try to actually sort of reconstruct the story. And I started with the impulse of, well, I don't actually know how this works. So let me go and try to figure out how. Okay, I will stop there.
Okay, well, thank you so much. So now we've entered the Q&A portion of today's session. I find this topic so interesting. I find what you do so interesting. And I'm going to get the ball rolling and selfishly use my power as moderator to ask a few questions, because this is really so, in a sense, it's funny. It's ironic because it's history, but it's so timely. So you mentioned early on about how you study people, and some people, some human beings are very flawed. And I really cannot think of anyone more flawed than Donald J. Trump. Genuinely. And when you mentioned that Davis didn't get tried for treason, the parallel came immediately in my mind how Trump, in my view, as a jurist, should have been tried for January 6th and wasn't tried. So is it a naive parallel to draw, or are we witnessing, in a sense, something repeating itself here?
Oh, it's such an interesting question. And I guess I'm also going to say that I find our president to be flawed. Yes. I think I can agree with that. Yeah. So it's interesting because uh so I mentioned at the beginning, right, that I feel like, oh, I'm rooted in the past, and I like to sort of stay in the past. I'm more comfortable in the past. That is true. And yet events constantly bring me screaming into the present, right? So I will say, so I wrote, I mean, one of the things that Davis's lawyers argue in his case, no, his case doesn't go to trial, but eventually, right, they get the charges against him dropped. And one of the things that they do is they argue, or they get the government to voluntarily drop the prosecution, but they argue in one of the iterations of his case, right? They argue that Section 3 of the 14th Amendment means that Davis can't be tried for treason against the United States. And this is the very clause that came up in some of Donald Trump's, some of his legal troubles. But there was this plan. The Supreme Court decided this case, I think it was last summer, Trump versus Anderson, about whether or not Trump could be excluded from the ballot based on insurrection against the United States. And indeed, Davis's lawyers used that very section to argue that he's not supposed to be prosecuted for treason, right? That the only punishment can be to exclude him from office, right? And it's, the court, there, he's tried before circuit court, and the circuit court decides there's a 2-to-1, there's a split in the circuit courts. This is not how circuit courts work today, right? But the two judges in the circuit court, one of whom is the Chief Justice of the United States, right? They disagree about whether or not that is the sole punishment for treason for somebody like Davis, who's implicated by Section 3. And that case is supposed to go up on appeal to the U.S. Supreme Court in 1869, and that's when the government drops the prosecution against him. But anyway, it turns out that Davis's case was a major precedent, right, in this Supreme Court litigation in Trump versus Anderson, right? And so I had written this stuff about Davis's case and this interpretation of Section 3, and it turns out that all these people wanted to ask me questions about Davis's case and how it related to Trump. And I thought, oh, I loved it when I was the least relevant member of the UVA law faculty. But here we are where, these cases, where there are all these questions, right? I think are, just purely of historical significance, and then they keep coming up, right? And so it turns out this is how law works, right? And so the interpretation in Davis's case, right? So it turns out that there are lots of reasons to maybe think that that the analysis was not that great in Davis's case. And anyway, these sort of get trotted out in Trump versus Anderson. So sorry, that was answering only part of your question, which was to say that yes, there are direct connections. I think, I'm going to address maybe the bigger question here, which is to say, I asked myself the question, and one of the sort of central questions in my first book is, well, how good is law at addressing sort of the biggest questions that we have, right? So the question of, slavery in the United States, right? Ultimately slavery in the United States, right, ends on the battlefield with a constitutional amendment as a follow-up. I'm going to say the same about secession, right? We don't get a constitutional amendment as a follow-up, but we do get a case as a follow-up. But these are big legal questions that I think, ultimately the courts are not that good at figuring out, right? So there were some cases about secession or test cases, ideas about maybe trying secession in the courts. And indeed, we don't actually get a court decision before the war happens. And maybe some of our biggest legal questions, we have trouble. We want our courts to be able to answer these questions, right? I mean, that's the whole idea of the rule of law, but maybe it's the biggest legal questions that it's very difficult, right, to have a court figure out. I mean, I don't know. I read some of the court decisions in the Trump cases as the Supreme Court saying, we don't want to figure that out, right? I mean, that ultimately they think that's really actually tough, right? In terms of the job of the judiciary, right, to decide some of these questions. I mean, I read the court's decision in some of the Trump cases as saying, look, we think maybe this should be left to the political process, right? So I don't know. I believe in court capacity, but then I also think there are some things that are maybe beyond court's capacity.
That makes a ton of sense. Simon.
Yeah. So I'm curious. I have two questions. One comes from my interest in methodology, and the other comes from my interest in property. So the first is about, I think conceptually you mentioned that there's a difference between originalism, right, and being a legal historian. So maybe on a broader level, what is the difference between a historian and a legal historian? And another thing that I think lawyers have to face is to evaluate evidence, right? When it comes to court and to see documents and to understand how do you evaluate them and the validity of them. So as a legal historian, how do you look into the different supporting documents and to sort of assess the importance of each and to frame or I don't like to use the term frame a story, but to really write a story that really reflects the truth. So that's my question on on methodology, and the other is about property. I'm just curious to learn a bit more about your discovery on land distribution, so when I look into property systems, because my interest is on the digital side, so I look into the past and to see how it can be reflected on the modern age. And I think that also requires a very good understanding of why certain provisions are created and the flaws of those provisions, and that we're not going to repeat those flaws again when we sort of apply them, in a broader or in a different context. So with that, what is there a provision on land distribution or land seizure that reflects the history, the history of Black people that is inherently flawed, or even systemic in a way that that is still influencing what we're seeing right now, some of the systemic racism that we see, or is it something that has like a different, like it just went on a different direction right now, when it comes to the current land registration regime in the United States?
Right. Okay, so two big questions.
Yeah.
Okay. Okay, so I'm going to start in order. Okay, so that's so interesting, and I'm so glad that you asked me about methodology from the sort of the history perspective, because I always get asked the sort of methodology from the sort of how does this, how does this affect, what I'm going to put into my brief tomorrow perspective. Yeah, okay, it's and one of the things that I think you're asking about sort of, like the interdisciplinary space, right? So I guess I don't know if this is a good thing to say to students or some people who are still students. You're a professor too, right? But yeah, but I feel like it's such an interesting space, because I remember thinking like, this is going to be great. I'm trained as a historian and I'm trained as a lawyer. And so I'm going to feel totally comfortable in both spaces. And that's true sometimes, but I'm going to say sometimes I feel uncomfortable in both spaces, right? For some of these reasons, right? Which is to say that sometimes I'm uncomfortable with how historians use legal materials, right? Which is to say, like, I've read plenty of histories, right, where somebody is, you know, somebody is using legal materials, and I'm going to say that particularly the farther back you go in time, right, legal materials are often what survives, right? And so you often get people reading legal materials, and they might be the center of the analysis. And sometimes you read histories where it's clear that somebody has no idea how to read this document, right? And I'm like, okay, yes, you can find what somebody said, right? But um, they said it because it has legal implications, right? And it's not clear that this is even true, right? I mean, anyway, all kinds of things about, they don't really understand, court process or any of that, right? And so sometimes I can find myself a little frustrated with how historians sort of treat legal materials, right? And so I think the same way that you have to know about, you know history and what you're doing and what you're finding, right? When you're a lawyer, right? And you may not be totally familiar with it. Same thing, I think, with historians who approach legal materials, right? I mean, sometimes the words or terms of art, I mean, particularly in property, all kinds of stuff, right? And so I think we do have to approach legal materials carefully. And often what I find myself doing, right, is I find somebody, I guess the way I start is I understand some property concept, let's say, right? And I think, oh, I understand how that works, right? And then I go into the past, and somebody starts talking about that concept in a way that doesn't make sense to me, right? And so often, I sort of expect them to say X, and often I find them saying something that's not quite right or not quite what I expect them to be saying. And as soon as I find them to be saying something slightly different from what I might expect, I think, aha, I'm onto something. Now I've figured something out. And the reason for that is because I feel like people in the past, right, I expect them to act a certain way and they almost never do, right? I mean, there's something recognizable, right? But I'm looking for difference, right? And so often what I have to do, right, is if I see somebody saying something in the past, I'm trying to evaluate, well, is that a good argument? Is that a good legal argument? And maybe I don't know. And so a lot of what I have to do is to sort of figure out, okay, well, what's the baseline? I mean, I'm talking about usually legal argumentation made in the middle of a civil war by somebody who has an agenda, right? Like they're trying to promote one side or another, right? And so I think, is this convincing? I mean, it's not convincing to me, but I don't know, right? And so a lot of what I have to do is just sort of figure out what's the baseline, right? So I would say doctrine is actually at the center of what I do. I mean, I talk about people, right? But to get to the story about the people and to sort of explore that, right? I have to do a lot of, like, I read a lot of old treatises. I read a lot of old law review articles to try to figure out, okay, so what was the law? What was the doctrine on this? Which parts were sort of um, up for grabs? Which parts were unclear, right? And then to what extent does some argument I see somebody making, right? Is it a departure? Is it a crazy departure? Is it in line with what I'm seeing? I mean, I guess I would just give you an example. There are lots of arguments in these are the context of property of land redistribution, where they're making arguments that the government's custody over property that was seized during the Civil War, the government holds that in constructive trust, right? So I'm a property person. I know trusts, I know constructive trusts, a little bit. But that analogy is sort of all over the place, right? So like, I'm just telling you, like, what am I doing this week? This week, right? My job is to figure out, I need to know a little bit more about the law of constructive trust in the 19th century, right? And it turns out like I picked some old treatises off the shelf, and it turns out that like half the treatise in some of these old treatises on trust has to deal with constructive trust, right? And today I don't think you'd see that, right? Like constructive trust is like a very narrow doctrine, but I think it's more capacious in the 19th century, right? And so I'm trying to sort of figure out, okay, so where do these lawyers have, like what's their sort of legal understanding as a baseline? And then where are they making sort of leaps and departures, right, from that sort of generalized understanding? So that's a lot of what I'm doing. So there's a lot of like doctrine side law of constructive trusts, right? But then there's also the putting together of human ingenuity, right? And how are people stretching those arguments? So that's what I would say in answer to your first question. Second question. Okay. Property and how I think about property in the 19th century and ideas about how that sort of maps on today. And you said many other things, which are also in my head. So this is interesting. I mean, so one thing that and you said you did stuff on the digital side about which I know very little, but I will just say this, that so one of the things that's interesting to me is that a lot of the law about land redistribution and land seizure, right, and the way that this worked, right, and the way that arguments worked, and maybe this sort of goes along with what I was saying earlier about doctrine, that the way that land seizure was designed to operate in the 19th century, or in the midst of the Civil War, they have analogies, right? Like, so they don't just invent this out of whole cloth, right? They have a blueprint, right? And the blueprint is the law of the public domain in the 19th century. Now, the public domain, I feel like today we tend to think of that with like intellectual property, right? But the public domain in the 19th century is land, right? And so I would say, for instance, like I talked about 40 acres and a mule. Well, one of the questions I had in my head was, why is it 40 acres, right? And the reason it's 40 acres is because that's what all the land grants look like in the public domain in the West in the United States in the 19th century, right? And so they are borrowing quite explicitly from like that law, and then they make leaps. And so actually that's part of what I, like part of what, the stuff that I learned, right, in order to write the book is I had to learn a lot about the public domain in the 19th century. I guess I would also say that one of the things that's going on here is sort of major changes in property law, right? And so we are thinking about like, well, how do we overhaul property in a major way, right? Because that's what they're doing here, right? They're thinking about property seizure in a way that, we tend not to do property seizure in the United States, and then actually reassigning it, right? Again, in these major grants in the 19th century. And I want to say that there's more of that sort of expansive type of thinking about, sort of really shifting property in the 19th century, in the 18th and 19th century, like maybe in ways that, I don't know, we sort of like fade into the back of our minds today. And I don't think we're that creative about this anymore today. I mean, maybe in the intellectual property space, I just don't know enough. But I would say one thing that comes to mind is the end of the fee tail in the United States, which starts in the 18th century. But it continues through the 19th century. And that's actually like that creates, in ways that we don't really remember today, creates major upheaval in the United States. And I think that they are they do think about things like, I mean, some things that maybe you wouldn't necessarily associate with this, like they also think about colonization and getting land overseas, right? Like, so Manifest Destiny and like Western land expansion, right? I think those ideas are actually sort of linked up in the 19th century. And so I think that, I don't know, the way that we sort of think about land redistribution and sort of major overhauls of American property rights, I think our courts are, I don't know, far less experimental about such things. And I think in the 19th century, there was sort of more room to think about sort of major overhauls.
So we're at the last 5 minutes. I know Sang-Shun, you wanted to ask a question?
Yes. Hi.
I feel like I talked too much. Okay.
I mean, you
Okay.
know, that's the beauty of a Q&A. Like the give and take is really, really interesting, to be honest.
Okay.
Thank you, Professor. I have two very short questions. My first one is, when collecting evidence to support your argument, like how much do you think is enough? I feel like sometimes when people may challenge you that and saying that, hey, you should collect like more evidence in a more broad time frame, or saying that okay, you only research on this specific region and probably you want to research on more places. Like if you research on Indiana, they will argue that, hey, you may also want to research on the Washington on the state. So and my second question is, I think most of the time history is not black and white. There are a lot of gray areas. So when you make an argument, I believe that somebody would say that would propose like different arguments saying that, hey, there are some exceptions, but sometimes you know that that exception is like a outline of things. So how do you like cope with this general like situations? Thank you.
Great. I want to say you have tapped into two of my big fears. Yeah, so exactly. I mean, these are things I think about all the time. First, I'm going to say, I am an archive rat, which is to say that I have been many places to do research. And so this question about like, could you find more is something that always plagues me. And I'm always somebody who's like, okay, let me figure out what this guy said, right? Like this, I have these people's perspective, but how do I get these people's perspective? And so I'm very interested in trying to tell a legal history from multiple different perspectives, like as many as I can get. And maybe too many. But even as you said, I mean, as you say, however many I get, there are always more, right? And there's always more work to be done. And I feel like I do research to the extent where I feel like I try to triangulate where I can, right, to find evidence. Like, I mean, there's lots of places where evidence is missing, right? We just don't have records, right? And so if I have a question, I try to think about, okay, so what evidence could get me to answer this question, right? And how could I possibly get at it, right? And I try to sort of brainstorm and think about like, what are the ways, what evidence could I use to try to support what I think might be right? But it's still, there are plenty of things I could look at that I don't. And I guess I do enough research until sort of like the stuff that bothers me about my story, like I'm missing this part. I don't understand this part, right? Or I maybe partially understand this part. I do research until I'm pretty satisfied with, I think I've told the story from enough perspectives that I'm pretty convinced about what I'm saying, right? And so you're right that there are still people who are constantly like, well, you didn't look at this, right? Or I have a different perspective, or you think that this person thinks X, but I actually think that they have a different perspective. And usually I feel like one of the things I do is I do my homework, right? Like I do enough work, right? When I say that I do enough work to satisfy me, I'm a pretty demanding customer. Um, and so I feel like when I feel like I'm pretty satisfied with like this is the story, and then the next thing I read in the archives, like I know who all the actors are, and I kind of, like until like I don't read I read enough until the next thing I read doesn't surprise me, right? I'm like, I know the story, right? And I feel like when I have a sense of the story, then I think I'm pretty confident, right? And I have the story in my head. Now you could surprise me. You could have a different perspective, sure, but I'm pretty confident of where I stand.
Okay, right on time. So unfortunately, we have run out of time. Thank you so much, Professor Nicoletti, for this incredibly insightful session. And also, we understand that today somehow history has become a subject of controversy. So we commend you and we thank you for being as brave as you are in your academic pursuits. And want to thank everyone for attending and remind everyone that we are all bound by the limits of respect. And just before you leave, if you don't mind all turning your cameras on, if we could take a group picture, if that's okay with you, Professor.
Sure.
Simon, can I ask you to do it?
Sorry, I'm in my office computer, so
Oh, you don't.
yeah. So
Look, everybody has a face.
yeah,
Everyone has a face. Oh my
Judy,
God.
Judy, or something. Are you able, or Vanessa?
Wait, I'm sure I can figure this out.
Are you
I'm
able
doing
to?
tax for
Okay,
Christ's sake. Okay.
okay. I know.
Okay, let's
see
do a
how many
countdown
PhDs it needs to take a screenshot.
to take a screenshot.
Yeah, Marilyn, are you able to do it?
Yes. Wait, okay, let me redo it. 1 second. Wait.
Do you need help, Madeline? I can help.
Yes, Susie, I think if we can retake it from
Thank you,
yours, because it
Susie.
took a screenshot, but not a one I like.
Okay, hold on, I'll just count down. 1, 2, 3. Okay, got it.
Thank you. Thank you so much,
Thank you.
everyone. Thank you, Professor.
Thank you all. Thanks for being so engaged.